Hello, I'm Advocate Nikita Pandit and I will be speaking on the copyright societies in India and you're watching Legal Bites. The main objective of this video is to understand the roles and functions of the copyright societies as per the Copyrights Act of 1957. What is a copyright society? A society of authors of different works under Copyright Act is called as Copyright Society. This society of authors of different works are made for better collective administration and management for protection of copyrights. This national society helps the authors to make sure that their works are not used in an unauthorized manner anywhere and also to collect the royalties from the transferees. It undertakes careful vigilance over the use of copyright. The National Society can also enter into agreements with other nations of international conventions where India is a member for the timely collection of royalties. This also makes the licensing process much more easier for the members of this society. Section 2, Clause FFD of the Copyright Act of 1957 gives the definition of copyright societies. It is a society registered under Section 33, Clause 3. After the 1994 amendment of this Act, only the Copyright Society has the right to give the license for the works. However, the owner of the copyright has the right to give the license, but the rights must be exercised only as per the rules and regulations of the Registered Copyright Society membership. 2012 amendment brought one proviso in this section. It provided that when any kind of work, may it be literary, dramatic, artistic or otherwise, if it is added in any cinematograph or sound recording, it is compulsory that the license is to be given only by the Copyright Society. Association of persons who want the society to be registered have to make an application in triplicate, that is 3 copies, to the Registrar of Copyrights along with the documents which are mentioned under Rule 14A. The true copy of the instrument that forms the Copyright Society, that is memorandum, articles, the consent of the individuals in the governing body, a declaration of the applicant stating who will act on his behalf and how the accounts will be managed, and a declaration that the terms of the instrument are as per the laws and regulations. Appropriate fee must be paid along with the application. Such association must consist of 7 or more members as per Rule 12 of the Copyright Rules 1958. All members of the governing body of the Copyright Society and chief executive of the applicant have to sign the application of registration. Registrar then forwards the application to the central government, usually for one class of work like art, drama, and so on. Only one society is registered, but this rule is discretionary. The central government considers the interest of the authors, owners of the work, convenience of the public, and convenience to the group of persons who may get the license of that work, and it also sees how competent the applicants are, that they have the funds for the management. It has to see that there is no already existing copyright society performing the same function, that there are all the bona fide copyright owners, and all make sure that application is complete. As per Rule 14, there are 2 main conditions which have to be fulfilled. Only then the registration can be granted, that the instrument, that is memorandum, articles, must be made only to deal with the copyrights and the related activities and nothing else. The second condition is that there must be willingness to follow the laws and rules as per the statute. These parameters are considered and accordingly the registration is granted to the Copyright Society of any class for a period of 5 years by giving a certificate of registration under the seal of the Registrar of Copyrights. This is renewable. Before the term of the 5-year ends, the Registrar of the Copyright has to update to the central government about the working of the Copyright Society and if it is up to date. The renewal of the next 5 years is given to the society if it is right. Consecutively, such renewal can be asked for. The condition to grant the renewal is that such society should even then have the collective control of the artists either in the capacity of the owners of the copyright or as a collective way to collect the royalties for the members. If in any way the central government feels that such copyright society is or will be harmful for the interest of the owners and the authors of the copyright, the central government has the power to hold the inquiry into it, and if it is found to be detrimental, it can cancel the registration of the society. Such inquiry is initiated by giving the notice along with the copy of complaint that is made by the registrar. They have to reply with a statement of defense in writing and statement if they want to present their case before the court. An inquiry officer is appointed who is equal to or above the rank of Deputy Secretary of the government, who makes sure that the rules of natural justice are followed in such proceedings. He can appoint another expert like CA or auditor for help, and the Copyright Society is duty bound to cooperate with the inquiry and furnish all required documents within 3 months. The central government can suspend the registration of the copyright for a period of 1 year in circumstances provided by the Act. The first scenario is when it is in the interest of the authors or owners of copyright. Another is when the provisions of the Act are contravened. Next is when there is any change in the instrument or document by which a copyright society is formed without providing the notice to the central government. As per Rule 14, instrument consists of the memorandum and articles of association. In such cases, till the inquiry is over, the registration can be suspended only for 1 year, and in that time the government can appoint an administrator to enter the shoes of the Copyright Society and carry out its functions. If the allegations against the Copyright Society are found to be true, the registration of the society can get cancelled. Before cancelling, an opportunity is given to the society to justify their actions. Copyright Society, as per Section 34, can get an authorization from the author or the owner to deal with the license. It can be for giving the license to some third party, or it can be for collecting the license fee from the licensee or on his behalf, or both. Such author or owner can also cancel the authorization given to the society for dealing with his work as mentioned before, but it should not harm the rights of the Copyright Society in any manner. Copyright Society can enter in an agreement with the foreign society or organization which undertakes the work that is similar to the Copyright Societies in India for administration of rights in such foreign country or in India as required. The function of Copyright Societies are as follows. The Act does not allow any kind of discrimination made by the society. There should be collective control over the administration of authors and owners. Approval must be taken by it from the owners or the authors for the procedure of collecting the fees on their behalf and distributing it between the members. If they want to use the fees for other purposes rather than distributing it amongst the members, the society has to get the approval for such other use. The society has to give the details of the functioning of the society to its members. The fee has to be distributed amongst the members as per the proportion of their respective work which is used. Society should have one governing body having equal members of authors and owners for administration. There should be equal membership rights, and these cannot be in discrimination. Copyright Society has to submit the report of working to the Registrar of Copyrights. The central government or its authorized officer can demand a report and records of the Copyright Society to make sure that the fees are used for the purpose according to the Act and not in violation of it. The Copyright Society has to compulsorily publish its tariff scheme, and on publication, if someone has a problem with it, they can approach the High Court in its appellate jurisdiction, and till the appeal is decided, the appellant has to pay the cost of appeals to the Copyright Society, and the same cannot be stopped even by the court order till the case is disposed. The High Court can direct to pay a fixed temporary tariff until then. In case of Anand Bhushan and others versus Union of India, the Indian Reprographic Rights Organization was the party. Delhi High Court has explained in its case that central government has been empowered to decide the procedure of publication of the tariff rates so that the Copyright Society does not collect from any licensee any minimum guarantee cost where the royalty will be determined solely on the sale at the end of the license period, unless the contrary is given by the tariff scheme. However, where it is necessary, such guarantee can be imposed, and if anyone has the problem, they can approach the Copyright Board for interpretation. It was also held that the tariff schemes help in bringing uniformity with respect to the license fees all over the nation. Some registered copyright societies in India are the Indian Performing Rights Societies Limited for literary works, Indian Reprographic Rights Organization, that is IPRO, for photocopy works, Indian Singers Rights Association ISRA for singers, separate performers society for each class of performance such as actors, singers, musicians, dancers, acrobats, jugglers and so on. One famous case involving copyright society was Indian Performing Rights Society versus Debashish Patnaik and others, where plaintiff was registered copyright society of authors, composers and publishers of literary and musical work. It prayed for the permanent injunction against the defendant for playing the works by the mechanical devices like radios, cables in the hotel without getting the license for them. The court ordered injunction against the infringement and also ordered the damages. Injunction was also passed to prohibit the unauthorized use in favor of the plaintiffs and the other sister copyrights. So these are certain important points regarding the copyright societies in India. Thank you.